Thank you all for coming. For those of you who don't know me, I'm Dominic Nockcliffe-Brown, Policy Lead in Medical Ethics and Human Rights here at the BMA. I'm also joined by Adele Hanley from Medical Justice. Both of our organisations are pleased to be able to bring you this joint event, Healthcare and Immigration Removal Centres, Lessons from the Brook House Inquiry. We're grateful for the participation of all speakers and attendees. Just before going into the event, a few, as always, some housekeeping points. As always, please can you make sure your phones are on silent. The event is being filmed and there's a photographer present also. Those who indicated that they do not want to be photographed or filmed should have that indicated on their badge. Please also note that the discussion with the former IRC detainee will not be photographed or formally filmed, so they are being privately filmed for their own benefit. You may photograph and post on social media this stage and what's going on at the front, but please do not take any photograph or film the part of the event featuring the former IRC detainee, and also please do not film or photograph the audience. We will take questions from the floor for the panel Q&A at the end, but you can also submit questions virtually and anonymously in advance by going to www.slido.com, which should be on the, yes, it's on the screen. And typing the event code BMA MJ IRC, all capital letters, all one word. Just to reiterate, that is just for the panel discussion at the end. We do advise that anyone who doesn't want to be filmed or photographed to submit their questions virtually online. And with that housekeeping out the way, I'd like to say a few introductory remarks on behalf of the British Medical Association. The BMA has long called for extensive reform of immigration removal centres in the UK. Our seminal 2017 report, Locked Up, Locked Out, stated IRCs should be phased out and replaced with more humane alternatives. If IRCs are not phased out, then the BMA believes at the bare minimum the government must introduce certain guarantees, including a time limit for being held in an IRC and high-quality healthcare proportionate to the needs of those detained. The government has failed in these regards. The Brook House Inquiry shone a light on the systematic failings at Brook House IRC, and during this event, it is through this prism we shall consider the wider circumstances of IRCs today and the healthcare issues that those involved in the system handle. This is all in the face of a political landscape of a government who, through their policies, legislation and rhetoric, have made it clear they intend to discourage and reduce migration, the Nationality and Borders Act, Illegal Migration Act, and the Rwanda Plan being three obvious recent legislative examples. It is therefore more important than ever we call out shortcomings in the UK's immigration system and work to ensure the highest quality of healthcare for those detained in IRCs. And with that, I'd like to thank you and hand over to Adele, who will give some remarks on behalf of Medical Justice.
Hi everyone, I'm Adele from Medical Justice. Just a few introductory remarks from us. So having been established in 2005, Medical Justice works to uphold the health and legal rights of people in immigration detention. We agree with the BMA that the unconscionable harm caused by immigration detention means that it must be phased out. Medical Justice is the only organisation to send independent clinicians into all immigration removal centres across the UK. Our clinicians produce medico-legal reports for our clients' legal cases, documenting serious medical conditions, scars from previous incidents of torture, and the deterioration they suffer because of immigration detention. We've been documenting evidence of medical mistreatment and harm caused by detention for the past 18 years. Our sizable and unique evidence is the basis for our policy and parliamentary advocacy, strategic litigation, as well as our research, and two of our latest reports are available here today. Following Dom's introduction of the Brook House Inquiry, which was the first statutory public inquiry into mistreatment and abuse into an immigration removal centre, we are delighted to have the chair of the inquiry, Kate Eves, with us today. Following undercover footage being aired by BBC Panorama in 2017, the Home Secretary was compelled to set up the inquiry due to legal proceedings brought by a former detained person subjected to the mistreatment. The inquiry's report, published in September 2023, provides a forensic analysis of the conditions that resulted in a failure to protect vulnerable people, exposing them to dehumanising abuse. Due to medical justice's expertise and extensive insight into failures of healthcare and clinical safeguards in immigration detention, we were granted core participant status in the inquiry. I'd now like to welcome Kate Eves to the stage to speak about her findings and recommendations. She'll take some questions at the end, but they'll be limited to her investigation. Thank you very much.
Good afternoon, everybody. Thank you very much for the invitation to come and speak to you today. It's been a little over 4 months since I published the report into the 2017 events at Brook House Immigration Removal Centre. I'm aware that some people in the audience obviously know a great deal about the inquiry and the events that led to it. Others may not. So I'm going to give some very basic background to what prompted the inquiry, talk a little bit about its scope in terms of reference, and then move on to the overarching findings and recommendations, focusing unsurprisingly on the healthcare and clinical aspects of it, which I am anticipating will be of the most interest to you. And I'm of course very happy to take questions at the end. So Brook House IRC is very close to Gatwick Airport. At the time in question, the Home Office had contracted G4S to run it. In September 2017, as Adele said, Panorama aired a programme which exposed mistreatment at the centre. The footage was captured on a hidden camera which was taken in by a young detention custody officer who had gone to the BBC because he was so concerned about what he saw and, as he later told the inquiry, had no faith in the internal reporting or whistleblowing systems in place. So various investigations followed. The police investigated. The CPS decided not to bring charges. G4S commissioned an investigation, and Stephen Shaw, who has done numerous investigations and reviews into immigration removal centres, was asked to consider some of the issues as part of a review he was already undertaking for the Home Office. In early 2019, the Prisons and Probation Ombudsman was asked to carry out what was termed a special investigation, and the then Ombudsman asked me to carry out that investigation. So a judicial review of that decision to commission a special investigation as opposed to a statutory inquiry was launched by 2 of the men who had been mistreated at Brook House, known as MA and BB. That JR was successful, and in June 2019, the High Court judged that statutory inquiry is necessary. Obviously, the judgment itself is very detailed. I'm going to just summarise 3 key elements that the judgment pulled out as the main reasons why a statutory inquiry was necessary as opposed to what had taken place up till then. The ability to compel witnesses to give evidence, the fact that the hearings would be public, and that would be properly funded legal representation for victims to allow them to participate effectively in the process. The terms of reference are long and detailed. And please do look on our website if you'd like to. I'm not going to read them out verbatim, but I am going to kind of highlight some of the key things about them, because this will then lead to my findings and the things that I think you will probably find of most interest. So one of the things that I was tasked with doing was reaching conclusions with regard to the treatment of detainees held at Brook House in that 5-month period of 1st of April to 31st of August 2017, where there was credible evidence that the mistreatment was contrary to Article 3 of the ECHR. So I was required to identify who was subject to that mistreatment and actually who was responsible for it. Those lawyers in the audience will be well aware that one of the key things about a statutory inquiry is that Section 2 of the Inquiries Act means that you cannot find civil or criminal liability. So the report, some of the terminology in the report may appear to the non-lawyer as very overly legalistic, but there are some kind of detailed reasons behind that. So in terms of the things that I needed to look at, I needed to look at the treatment of the complainants, including identifying the responsibility for that mistreatment, whether the methods, policies and practice of the Home Office and its contractor actually caused or contributed to the mistreatment. I'm going to whiz through these a little bit and just highlight the ones that are going to be of most interest to you. Whether the clinical care issues caused or contributed to any of the identified mistreatment, and whether any changes to clinical care would help to prevent a recurrence of that mistreatment. Just some basic stats about how long we took. how much evidence we had. So we ran for a little under 4 years. Disclosed material was over 9,000 documents, which amounted to over 100,000 pages of documentary evidence. A lot of footage, which was viewed, clipped, subtitled, pixelated, subtitles redacted, so a long process to go through that. We heard from 101 witnesses, 78 of those in person giving oral evidence. 4 of those who'd been formally detained. I also allowed all evidence to be read in by the legal representatives of some of the men who'd been formally detained, because I felt it was really important to hear it in their voice, although for various reasons they were unable to actually appear in the evidence room itself, in the hearing room. The report is 711 pages long, so it's not an easy flick through. I commissioned 3 experts as part of the inquiry's work, so one who was a clinical expert, a clinician, an expert on the use of force, and an expert on cultures within immigration removal centres, so the head of the criminology department at Oxford University. I concluded that, having looked at all of the evidence, that there were 19 incidents where I found credible evidence of mistreatment which was capable, I warned you about the legalistic language, my apologies, capable of amounting to mistreatment contrary to Article 3. This included inappropriate use of force against detainees, including a particularly serious incident where a man who was highly distressed had the hands of an officer placed around his neck. Unnecessary pain being used on detainees, forcibly moving detainees while they were naked or near naked, dangerous restraint techniques being used, including a restraint technique which had been associated with the death of a detained man, Jimmy Bamber, the use of inappropriate and humiliating comments against detainees on occasion during suicide attempts, homophobic comments against a detainee, initially failing to help a detainee in the immediate aftermath of a suicide attempt. There's one volume of the report talks in detail about each of those 19 incidents, and there is a lot of footage that accompanies several of the incidents. I would urge you to look at it because it's a really important visceral demonstration of actually what was happening. So I also found that, as well as those 19 incidents, the thematics, which when woven together, in my view, created a really toxic culture at Brook House, and this made it more likely that mistreatment was going to occur. I found that the physical environment of Brook House was completely unsuitable for detaining people for anything other than a short period of time. And one of my key recommendations was that there should be a 28-day time limit on detention in any setting which is designed, such as Brook House, the specification of a prison. I found the indefinite nature of detention relatedly caused anxiety and uncertainty. I found that too often there was a failure to follow the safeguarding rules and procedures that were in place specifically to protect the most vulnerable. I found examples in relation to the use of segregation, when and why and for how long people could be segregated. And in my view, this left detained people exposed to harm. I actually found that the safeguards in many instances were fine in themselves. It's just that there was a misunderstanding or a disregard for how they needed to be implemented. I also found significant and widespread failure to properly implement the safeguards relating to Rule 34 and 35, and I'll say a bit more about that in a moment. As many of you in the room will know, there are high levels of mental ill health in the detained population, and a significant proportion are likely to be acutely vulnerable. I found that medical staff did not understand their safeguarding duties around some of their own responsibilities to protect individuals who are particularly vulnerable, especially in relation to the use of force. Many of the most concerning incidents did relate to the use of force. I've talked about one of the most serious, which involved the application of pressure to a detained man's neck. Fundamentally, and I've made a recommendation to this effect, it's my view that the approach to use of force in immigration removal settings is not appropriate because it is modelled on that is used in prisons, and immigration removal centres are not prisons. I've recommended that there needs to be a review of what approach is appropriate in these settings, taking account of mental health issues, the fact that often force is being used for very different reasons for why it is used in prisons, issues around language and communication, and the paucity of other systems that would be in place in a prison which are not in place in an IRC. Then finally, on the broader issues, I found that there was significant understaffing, a dysfunctional G4S senior management team, a lack of responsibility on the part of the Home Office to actually to see themselves as the safeguards for how things were working in the IRC, too much responsibility left in the hands of infrequent inspections and volunteer lay observers through the Independent Monitoring Board. Generally, I was really alarmed by just the level of desensitisation amongst staff to the distress that they were seeing on a daily basis. How am I doing for time? Okay, so in relation to healthcare, I'm going to kind of group this into a few main areas. The report, there's a huge amount in the report about this, so I want to do it credit, but I also know that there's a huge amount of detail, and so I'm going to give kind of some surface level findings, and I would urge you to read it. So there was a failure to apply Rule 34 and Rule 35 effectively, part of the issue being that the two things had been kind of artificially removed from each other. So the purpose of Rule 34, which requires a medical examination of every detained person by a GP within 24 hours of their arrival, also serves to identify those who may then need a Rule 35 report. The outcome of separating those things was often a delay between doing a Rule 34 report, which sometimes itself was just actually a 5-minute appointment with a nurse rather than an appointment with a GP, meant that there was a delay between that and then having the Rule 35 report, and actually 75% of the Rule 35 reports that we looked at were inadequate. There were no Rule 35 reports on the on the second limb relating to those who would be at significant risk of suicide, which I found very difficult to reconcile with the fact that, that there were numerous people throughout that period who had been identified as so at risk of suicide that they were actually under constant watch. So the fact that there was just a complete mismatch between those figures I found completely unacceptable. My concern about the lack of training, I think I've been asked to sort of touch on where I can the things that perhaps are still relevant now. Obviously, the period of time that I looked at was the 5-month period in 2017, but we did take some evidence from Serco, who now run Brook House, and in my view, that some of the misunderstanding and the lack of appreciation of the importance of those systems persists now, or at the time of taking the evidence before I issued the report. So the other key area of concern was that of the healthcare role during use of force incidents. So again, summarising this and simplifying it a great deal. So firstly, around the fact that healthcare staff have a responsibility to indicate where they believe there are risks to using force against an individual who's been detained. And I found instances where no contraindications were raised, despite the fact that somebody had significant physical or mental health issues, which meant that they were particular at risk should use of force be used. Identified there being a tension between the healthcare professional's obligation to act in the best interest of the patient and their involvement in the use of force in custodial settings. I also was concerned about instances where we saw concerning uses of force where there were healthcare members of staff present and yet they did not raise the alarm. Again, the most concerning relates to the incident that I've now mentioned twice, where a man had hands put around his neck. A member of healthcare staff was present, didn't stop the use of force, and didn't appropriately challenge the actions of staff either at the time or afterwards. I found that there was just a lack of understanding amongst the healthcare witnesses of what their role was, and that this needs to be rectified. Concerningly as well, evidence of the Home Office asking GPs to write letters regarding the fitness to fly or fitness for detention of individuals, and in some instances where there was no adequate physical or mental health assessment carried out prior to writing such a letter. So significant concerns about somebody's mental or physical health appeared to be missed. Though also, perhaps even more concerningly, in some instances, appeared to be what was a preemptive, positive approval by a GP for a planned use of force, which in effect became a sanctioning of that use of force, which I found completely inappropriate and of serious concern. And again, there are details about those incidents in the report. This, I suspect, for anybody who has worked in any secure setting will resonate. And certainly myself, having worked not only in immigration removal settings, but also in prison settings as well. I think, you know, it's not unique to IRCs by any means, but issues about the sharing of appropriate information related to healthcare between medical staff and non-medical staff to ensure that actually information about what's happening to a person is being shared appropriately, and that where somebody is missing multiple mental health assessment appointments, there is an appropriate sharing of information about what might be happening to that person when they're on the wing, leading to them missing those appointments. And I therefore made some recommendations about the ability to transfer routine information of relevance appropriately between people that need to know, to ensure that they're actually identifying where there are problems. So I'm often asked, okay, what happens now then? I made 33 recommendations to address these widespread failings. 28 of the recommendations are for the Home Office, albeit sometimes jointly with others, such as NHS England or contractors. 2 are for the government more widely, the one around the 28-day time limit, for example. I've asked the Home Office and any other recipients of recommendations to respond within 6 months. We're just over 4 months, as I say, so the clock is ticking. Unfortunately, there is no power on the part of chairs of public inquiries to actually compel a response to those recommendations. So what I have done, and I've indicated this in the report as well, is sent it to the Home Affairs Select Committee and the Joint Committee on Human Rights, and I very much hope that they will play an active role in monitoring when that response comes and the adequacy of that response. It's also obviously really important to be able to engage with professionals such as yourself to be able to explain the findings and the reasoning behind the findings. Because again, as I say in the report, with really depressing regularity, I've made broadly similar findings to recommendations that have been made by many people that have come before me, recommendations that still have not been acted upon. So with that, I'm very happy to take any questions.
Thank you. Thank you, Kate. Just so we do have a roving mic, so if you'd like to ask Kate a question, please stick your hand up and my colleague Maddie will be over with a mic.
Thank you very much. My name's Julian and I work in the BMA's Ethics and Human Rights function. And I'm once again incredibly troubled by some of the things that you have pointed out. And this idea that there is a role for health professionals, in a sense indicating in advance that people may be sufficiently healthy to have some of their serious rights abused or violated or infringed. And I wonder if you could just tell us a little bit more about those ethical conflicts, because I think for us, you know, Dom and I will work together, I think for us that's really at the heart of this, is that those obligations seem to be irreconcilable to me, professionally irreconcilable, and doctors should not be put in a position to have to do that, and nor should they undertake to do that. It is not a professional obligation that is reconcilable with their core professional ethics. Thank you.
Thank you for the question. So I think, I mean, I agree. I found it extremely troubling that I think there's one particular letter, and again, it's evidenced within the report and referenced, where I think the exact quote is "happy for reasonable restraint to be used," and I just find that at odds with the responsibilities of a clinician to effectively be sanctioning. I recognise that there are realities of working in secure settings, but one of the recommendations that I made in relation to this was the need for such professionals to be really clear about what their obligations are as registered clinicians, and that they're not there at the behest of the Home Office to rubber stamp certain actions. They're there as clinicians. I mean, I welcome your question. I think it's a really important debate. It's one that I hope you will continue to have as the professionals that are kind of faced with that challenge.
Hi, Helen Salisbury, GP and erstwhile visitor at Campsfield House, but that was a long time ago. You just talked about professional registration, and I mean, I know there may be degrees of lack of faith in the General Medical Council, not sure about the Nursing and Midwifery Council, but clearly if there are medical professionals who are failing to intervene while harm is being done, or sanctioning harm to be done, that could or should be brought to the attention of the people who regulate them and give them a licence to practice.
My report was sent to the GMC.
Did they do anything?
I don't actually know what the outcome was, or is. I imagine anything that they are doing is still ongoing. It was September that the report was issued, so yeah. But I, take the point.
I want to say first, my name is Yasmin. I'm from JCWI with my legal casework colleague. I want to say thank you to the BMA and the Medical Justice for hosting this. It's such compelling evidence and it needed to be shared. Before I ask my question, I wanted to just agree with the colleague from BMA who mentioned about how do you reconcile the Hippocratic Oath and the safeguarding of patients with some of what you've witnessed. I really do find that very as somebody with a background in public health, I found that very, very troubling. I wanted to ask, as an unfortunate term, inquiry wash, right? Which is that you can have these inquiries and not necessarily see, and as you said, enforcement, and not necessarily to call that particular responsibility out, but also to ask of what you've seen, what is it that we in the sector can also do? So at the Joint Council for Welfare of Immigrants, we have colleagues go into detention centres and support and do the legal work. What is it that we as a sector, whether we're in healthcare or working and providing legal aid support, and also yourselves having pulled together this powerful evidence, made this compelling case, where do we go from here, and not just wait for the clock to run down another 2 months and then find that maybe they want an extension on that, and then maybe find that actually there's not much of a response that is satisfactory to any of us here who are clearly here because we care and we're concerned.
Yeah, thank you. It's incredibly difficult, isn't it? And I'm sure that if you asked any chair of any statutory inquiry, they would share the same frustration that actually that having lived and breathed this evidence for 4 years, and the cost to the public purse, the cost to people that have contributed and participated in the inquiry, it would be, in my view, completely unacceptable not to respond, and not to respond in a meaningful way. One of the annexes in my report is essentially setting out all of the previous recommendations that have been made, so that it's really palpable just how often we're repeating the same things, spending the public money to look at the evidence, say the same things. I think it's keeping on top of the issue, having the conversations, not allowing the report to sit on a shelf somewhere. And that's why I've kind of been out telling everybody I can, as much as I can, about the recommendations. Obviously, there comes a point, actually tomorrow, day after tomorrow, where I'm formally no longer the chair, and so you hand over the report to people who can take the findings forward in those various different ways that different organisations can. But I'm really glad to have the opportunity to speak to you as clinicians, because I think the work that you do in the field and the issues that you see in the field are key to keeping this conversation going. I'm sorry it's not a more concrete or hopeful answer.
Kate, hi.
We are going to have to leave it there, but Kate, thank you so much, not just for this talk, but also for the fantastic work of the inquiry, so thank you very much.
Thank you.
We're going to move straight on to our next speaker, who's Dr. Brodie Paterson, who will be speaking on the use of force in mental health. Brodie is a mental health and learning disability nurse practitioner, academic and researcher who has held posts in the NHS, academia, private and not-for-profit sector. That's a lot. So with that, I'll hand over to Brodie.
Thank you very much. Yeah, I'm very old, so I've done quite a lot, I suppose, with that great age. First of all, thank you very much for the opportunity to speak, and thank Medical Justice very much for the opportunity to prepare a report in this inquiry. It was a sobering task. The report is a sobering read. It reminds us that some very bad things happen to some very vulnerable people, and that should trouble us all, personally and politically. I was asked particularly to look at the use of force in detention settings. Now, looking at the use of force in detention settings to a certain extent overlaps with culture, because culture and use of force do have a tendency to go together, unfortunately. So in my brief discussion, I'm going to touch on them both. A couple of starting points which are general as opposed to specific to Brook House. First of all, the legitimisation of the use of force in any setting where people are compulsorily detained and there are significant inequalities of power creates a potential problem. We know that where force is legitimised, even in extreme circumstances, a phenomena described by a colleague of mine, a theologian, Mark Chumensky, as a slippery slope occurs. Once permitted, creep occurs. Force starts to become normalised, and the use of force can start to become normalised. This is a widespread phenomena. It's a long-standing phenomena. And the misuse of force is one of the defining characteristics of what are known as corrupted cultures, and corrupted cultures, unfortunately, can develop in scenarios where we have significant inequalities of power where the use of force is permitted, particularly where the detention of the individual is associated with some form of labelling and all that goes along with that. When we start to look at the needs, particularly in relation to a setting such as Brook House, where a significant number of vulnerable individuals were admitted, a whole series of specific issues come to the fore, however, and we need to adopt a number of lenses to make sense of what's going on. One is we need to first of all think about trauma, and we need to think about trauma as a root cause of distress, and trauma as a root cause of sometimes a behaviour which may challenge services. If we adopt that trauma-informed lens and we think about how trauma may present in that population, and that includes individuals who have previously had experiences of torture, then we start to see phenomena such as hypervigilance and such as dissociation, and these are common presentations. And individuals may have one, they may have the other, they may cycle between the two. Under stress, symptoms which have previously been in abeyance may come back into the foreground. So it's not a static phenomenon, but it's a significant phenomenon. Now, that vulnerability has a whole series of implications when it comes to the use of force, because we know that the use of force and the use of coercion in any form can potentially be triggering for trauma, because the use of force in the context of an inequality of power is typically one of the dimensions of the original trauma. So anything that recreates an aspect of that original trauma has the potential to re-traumatize. So there's several implications of that when we think about the potential for the use of force. First of all, we need to try and create a dynamic in which the use of force or any form of coercion is utterly minimised with that population who are particularly vulnerable. Irrespective of whether the individual is detained or in the community, coercion is a problem and a potential trigger. We need to think about the principles of trauma-informed care in terms of empowerment, in terms of involvement in active decision-making. If we have a situation where force may be used, we need to ensure that we have sufficiently robust governance to ensure that it is only used in situations of extremis, only in situations where a failure to use physical force would leave the individual at greater risk than not to use physical force. And that decision needs to be taken at an individual level, on a situation-by-situation dynamic, thinking about the welfare of that individual and the physical and psychological impact of a potential restraint for that individual. It is a case-by-case decision. We need, however, in order to generate that kind of dynamic, where restraint is minimised, where its use is restricted to very specific in a very narrow range of circumstances, where we start with the presumption that the restraint is not justified and ensure we find the evidence to ensure it is justified. So we start from a presumption that restraint is a never event, something that should not happen, and that our efforts to prevent it should be considered a failure, and move back to learn from those. And then we start to think what we need to put in place to create that. Now, one of the problems in Brook House is, even when we have a well-run, acute inpatient mental health unit, adequately staffed, cohesive, consistent staffing, a very clear focus on trauma, a very clear focus on relational approaches to manage and contain distress as opposed to physical force, the challenges of supporting an individual who may have experienced significant trauma are significant. They can lead to negative feelings in staff. People's persistent dysregulation, the persistence of their coping strategies can cause staff, even in those settings with good access to restorative distress, to start to experience negative consequences. Malignant alienation, a phenomenon where staff start to perceive the person's behaviour as willful rather than a function of their mental distress, is a common phenomenon and in extremis kills people. The challenge in Brook House is Brook House did not have a positive culture. It did not have any significant understanding of the impact of trauma on the population it served, and actually on the staff involved in providing that service. Because trauma-informed care is not simply about thinking about those who have lived experience, it's thinking very much about those involved in providing the service. It did not have adequate training. Kate made reference to the prison service model. The prison service model was completely inappropriate. When you train people in physical interventions, you must wrap that training in physical interventions around with messages around culture, messages around self-regulation, messages around mindfulness, messages around ethical decision-making. You must ensure you have robust mentoring to ensure that these messages are put into place and consistently reinforced in order that they become embedded. The training provided by the prison service did not convey those messages. It did not have the wraparound. It conveyed, indeed, the hostile messages. That these people are at it, that these people need to be taught a lesson, that we should use the opportunity of this restraint to teach the person a lesson. Those are the antithesis of what is needed in that situation. There have been some positive developments in the IDC aside from Brook House. It is encouraging to see some particular changes. But what Brook House needs to do, and what the Immigration and Detention Service needs to do, is embrace good practice elsewhere. We have significant new guidance from the Department of Health, and I was one of the authors of that guidance, which addresses the issue of governance for all NHS inpatient mental health services. It's very, very specific about what needs to be in place in order to ensure that restraint is minimised and restraint misuse is actively addressed. We have existing standards developed by the Restraint Reduction Network, of which I have the pleasure to be a trustee. Those standards are subject to revision, and the new standards will be yet more robust in terms of covering training, because training is an important part. But training is one part of the jigsaw we need in terms of governance, in terms of resources. Brook House had an inappropriate culture, had an inappropriate physical environment, had inappropriate training, had inappropriate leadership, had inappropriate oversight. If you were trying to create a service that would go wrong, then Brook House is a recipe for how to do that. G4S did not have the expertise to manage that service and did not develop the expertise to manage that service over the period in question. Vulnerable people were left at risk. That's an unacceptable situation. It's easy to blame individual staff, and looking at some of the practice on display, I served on the Nursing and Midwifery Conduct Council for a number of years. I was appalled by some of the practice I saw. And I understand that a number of nurses have been removed from the register as a cause of that. But it's too easy, I think, to blame individual staff. The hostile climate which permeated what went on in Brook House was not created by the staff within Brook House. It was a political choice. IDC, working with individuals with significant distress, is not an easy job. It's not an easy task, even when very well supported. Those staff were not well trained and they were not well supported. It's too easy sometimes for those of us who are not on the floor to look at their decisions and blame them. If we fail to put the infrastructure in place if we fail to put the ethical infrastructure, the resource infrastructure, the training infrastructure in place, such services will fail. The lesson from Brook House is unless we get it right, services that fail, vulnerable people get hurt. A specific point, and a very specific point I wanted to make at the end around the use of pain, and in particular use of pain in the context of restraint. Use of pain in the context of restraint is controversial. There have been big moves across mental health services in the UK to move away from any use of pain. And pain compliance is a procedure which some of you may be unfamiliar with. I do have familiarity with it, whereby we place the person in a situation where we imply significant pain in order to induce their compliance. The problem is where an individual has experienced significant trauma and is dissociated, or is so hypervigilant they're not processing verbal information, or is so deluded they cannot process information. The rationality necessary to justify the use of that procedure, the ethical rationale for that procedure, that we will use pain, the individual is in a position to make a rational judgment to change their behaviour, is not there. Rationality is not there. In the absence of rationality, the use of pain is not akin to torture. It is a form of torture, and in such services it should not be used. Okay. A very blunt point to end on. I'm happy to take questions for a couple of minutes. I can be as well, so you have my sympathy.
Needed a mic. Well, my name's Syra. I'm one of the solicitors at JCWI, and we do, quite a bit of work around, clients who are detained. In terms of use of force, and would you agree with this rhetoric that the practices and the cultures that have now existed within our detention services really do stem from the wider culture of vilifying the migrant community and the people that have been detained and their liberties have been taken?
I think the climate of hostility has absolutely played a part. I think there's an element of dehumanisation that sometimes takes place in order for staff to try to protect themselves, but the interaction between those two has absolutely been toxic, yes.
Brodie, we've met before. My name is Stephanie Harris. I'm a barrister who's involved in the Brook House Inquiry. I wanted to ask you this question about the situation in an immigration removal centre, which may be distinct from other custodial settings, such as a prison, or if you're in a mental health hospital, having been sectioned, which is, in an IRC, there isn't a mandatory requirement for you to be detained. It is a discretionary power, an administrative power, and all of the policies that were highlighted by Kate in her talk were about how you identify those who are unsuitable for detention. Those with a vulnerability, had a history of trauma, if they have mental health problems, they are recognised on the basis not just of some kind of generous policy, but long-standing evidence. Professor Katona has documented it along with many others, including in the Shaw Review, that being in a detention facility of that kind is damaging to your health, and it's more damaging the longer you're in there, which is why I'm imagining Kate recommended 28-day time limit, because all the evidence shows that it's very damaging. So in that context, sorry, that's quite a long prelude, but that's the context, which is different from other contexts. Facilitating the use of force to manage mental health or in response to trauma or distress, do we have to look at, to really question that? We want to have good practice, we want to not repeat what's happened before, but what's your view about what's the key change in mentality if you have a person who is so unwell that they need force to manage their behaviour? Maybe they need to be moved to segregation, that's the general pattern. Isn't the answer not better forms of force that's more humane, but actually you should be released from detention?
Probably three quick points in response, Steph. One is, if you have good grounds to believe that an individual may suffer significant deterioration in their presentation, if you detain them, then don't detain them. That is my understanding. That was Stephen Shaw's recommendation. If you do admit them, have a rapid system of identifying when the individual deteriorates and ensure it's followed through robustly, so we minimise the potential negative effects. Third issue, I think, is to potentially think if somebody has a significant mental health issue, there may be an issue that they need to be in an appropriate place. As I recall, Stephen Shaw talked about the principle of equivalent care. We need to ensure the principle of equivalence applies. And whilst we may find it difficult to apprehend, restraint should always be only and ever an act of care. It should not be an act of punishment. It should be something designed to fundamentally be exercised in that person's best interest in order to protect them or sometimes other people from serious harm. It is a safeguard in some services. The problem is it has an inevitable tendency to be misused. There's a temptation to suggest in many services we should never restrain. The problem with that, in terms of our responsibilities, in terms of duty of care, that poses significant challenges as well. The real world is messy and complicated, and we need to find a way of managing difficult things better than we do, and find a way of consistently managing difficult things better than we have done.
We have time for one more question.
That was a long answer to a long question, Steph. Sorry.
Hi, I'm Adam, a GP from East London. It sounds like this is incredibly complicated and requires well-trained staff. Is there a tension that private providers, whose focus is often on cost efficiencies, may not have the incentives to train staff adequately enough? And do we need to look at whether private providers are appropriate to give this high-level care?
You're asking a socialist and a Republican with a small r his views on privatisation. I would, even irrespective of the issue of restraint, I'm probably going to agree that the state has a duty to support vulnerable people. Let's be mindful, however, the state has not always done well by vulnerable people. We've seen recent inquiries in mental health into Manchester. The problem of corrupt cultures can occur in many settings. I do think there are particular issues in some instances affecting private providers because of the focus on maximising return on investment may mean that there's less investment in the preventative elements that really need to be in place. You cannot run those services for cheap. The infrastructure is actually expensive, and the infrastructure is the people. You can contain distress through physical force cheaply. Containing distress through relational holding takes significantly greater investment over a significant period of time. It's not cheap. It is ultimately more effective, but it's not cheap.
Thank you so much, Brodie, for your presentation. That's really
Thank you. My apologies, I'm not going to be able to join you later. I have to be up in Scotland tomorrow supporting a political campaign for a new government.
That's great. Thank you very much. I hope you've all enjoyed, if that's the right word, what you've heard today. Appreciated, perhaps, is a better choice of English. And thank you all for coming on a day that's quite difficult for travel for quite a lot of you. My name is Andrew Green. I'm a GP by training. My job here today is to get you home not too late. We do have a little bit of flexibility with time. We're probably running about 10 minutes late. But I hope to get you home in good humour, roughly on time. I'm sure you'll help me with that. I'm here because I'm one of the deputy chairs of the BMA's Medical Ethics Committee, and I'm surrounded, I'm very pleased to say, by a very illustrious and knowledgeable panel. I hope that we can exploit them mercilessly over the next 40 minutes. I'd like to give them all opportunities to introduce themselves and say a few words about why they're here and about the most important things that they think we should be taking away from today's meeting. So I'd like to start on my far right with Dr. Cornelius Katona, who, amongst many things, is the Royal College of Psychiatrists lead on refugee and asylum mental health. Thank you so much.
Thanks very much. So, as you've heard, I'm a psychiatrist by trade, and I've been involved in refugee and asylum mental health work for nearly 20 years now. I was interviewed on the Panorama programme that started this whole thing off. So I was in the unfortunate position of being one of the first few people to see the terrible footage that we've heard about today. I've been asked to say a few words about detention and mental health, and I think it might be worth beginning just by reminding ourselves who is in detention. And in the detention estate at any given time, there are about 3,500 people, up to 3,500. Over a year, there will be something over 20,000 people who have been in detention, in the immigration detention estate. And that number fell somewhat during COVID. And some of us have argued that that was a sort of natural experiment, and that it ought to have been an opportunity to look at how necessary detention is. Sadly, the Home Office did not take that view, and numbers have gone up and are continuing to go up since the pandemic subsided. We need to remember that, and we've already heard this, that IRCs are not equivalent to prison. They don't serve any of the primary functions of prison, of retribution, incapacitation, deterrence, and least of all, rehabilitation. Their primary purpose is administrative, and length of detention is uncertain. As we've already heard, that's one of the key elements, that terrible uncertainty. In prison, you count the days down. In detention, you count them up. In terms specifically of mental health, it's worth remembering that there are some specific mental health conditions which seem to be particularly common in detainees, and I've now twice, and I'm in the process of doing this for the third time, carrying out a systematic review of all the research evidence on this, and it's pretty consistent. A lot of depression, a lot of anxiety, and above all, a lot of PTSD. And that comes back again to what we've heard previously, the notion that a lot of people in detention have been severely traumatized. There's also increasingly consistent evidence that the longer people are in detention, the worse their mental health. And the call that Kate Eves and others have made for detention being limited, and specifically limited to 28 days, there's pretty good research evidence for that those people detained for a month or more are considerably more likely to have mental health problems, and their mental health problems are likely to be more serious. So we need to ask ourselves why that is, and I think some of the reasons are fairly obvious. There's a diminished sense of safety, a diminished sense of freedom from harm, and as a previous speaker has said, there are often painful reminders of traumatic past experiences of detention, and sadly often of ill treatment. There's an aggravated fear of the imminence of return to something that at the very least people don't want, and very often they fear because of, let us say, further torture or what they see as impending death on return to their country of origin. They're also separated from any support framework that they have been able to create for themselves, and there is very high risk of disruption of care for long-term conditions, particularly long-term mental health conditions. So people going in and people going out of detention are at risk of their long-term treatment being interrupted. So in the Royal College of Psychiatrists, we've argued for a long while that people with mental disorders should only be detained in very exceptional circumstances, as used to be the case, but that notion of exceptionality has been dropped and not come back. That alternatives to detention, which have been increasingly evaluated and found superior in a wide range of outcomes to detention should be considered at all stages, that people in detention should receive optimal care, which of course is not possible because of the nature of the detention setting. And there's also a point that we've made in our college recommendations about staff. Staff in detention centres need training and support, not only training and support to identify mental illness, but also to avoid their own burnout and the consequences of that burnout. So, in terms of the questions, and much of my work is writing expert reports in asylum seekers, and many of those are in people who are or were in detention. What are the key questions? And I think the main question is, what evidence is there of vulnerability, such as torture or human trafficking, such as pre-existing mental illness, such as possible lack of capacity to make key decisions, decisions like whether they can challenge their own detention, whether they can challenge their immigration process, whether they can challenge or agree to medical treatment or examination. Another fundamental question is, have their mental health needs been met in detention? Do they have a care plan? Does that care plan address their recovery needs, not just their immediate safety needs? Have there been discontinuities of care? And maybe more important than any of those is there evidence in the detention setting of deterioration? And that encourages me to mention that the third limb, actually not the third, but one of the limbs of the Rule 35 process is the question of, has detention caused or will it cause deterioration? And the problem with that, and it's very seldom completed, but the problem with that is that there's no monitoring mechanism, and therefore that question about deterioration is very often just not triggered. So should we be monitoring regularly whether people in detention are experiencing worsening health? There's no mechanism for that. And finally, of course, and we've heard a lot about this already, is there evidence of suicide risk, and has that suicide risk escalated in detention? If those questions were addressed, I think there is fair hope that a lot of people inappropriately in detention would not remain so. Thank you.
Thank you so very much. I'd like now to turn to my left, please, to Dr. Rachel Bingham, who is a GP, and she is a clinical advisor to medical justice.
Thank you. Thank you. So, thanks very much for having me here. Medical Justice, as you've heard, have a network of independent volunteer doctors who visit people in IRCs, immigration removal centres, across the UK. And our doctors produce medical legal reports for people's asylum case, documenting evidence of past torture, or in cases where the person has experienced medical mismanagement, mistreatment or use of force in immigration detention. And those reports form a continually growing evidence base about our clients' health and their treatment in immigration detention. I'm going to say a few words about safeguarding, which we've heard some about already from Kate Eves. So as Professor Katona has explained, our background population is a population of many asylum seekers and people who have had high risk for mental health issues, high rates of trauma in the past. So our baseline population is quite a high risk population. And then those rates of mental health issues, as Professor Katona has said, increase once inside detention. And we see that physical health issues are also quite prevalent in this sample, often exacerbated by difficulties accessing healthcare in the community prior to detention. So this starting point is a group of people who are already at particularly high risk of being harmed by the conditions inside immigration detention. And yet, there's no effective health screening mechanism prior to detention to identify those people at risk. as doctors in the community, we're not asked about the risks that immigration detention would pose to our patients. So mental health issues, outstanding hospital appointments, ongoing specialist medical care, ongoing therapy are all interrupted. And this puts healthcare teams inside detention in a very significant, unique position, because for most people who enter detention, they are the only medical safety net, the only chance for people whose health is at risk in detention to be systematically identified and flagged up. And that brings us to the first hurdle, which is healthcare screening in detention. So Home Office rules, as we've heard, specify that every person would receive a physical and a mental examination within 24 hours, which should identify those at risk. At Medical Justice, we recently audited the files of 66 clients in the last year who'd had significant mental health issues in detention. So this data is quite up to date. Of those 66, only 37, just over half, had an appointment with the doctor within 24 hours. For the others, the waiting times went up to 2 months, and 3 were not seen by a doctor at all while detained. There's many reasons for this. At the Brook House Inquiry, these vital assessments were described as 10-minute appointments up to this day. So naturally, immediate medical healthcare needs like re-prescribing medication can take priority. And even if people are asked about a history of torture or mental health problems, non-disclosure can be quite high because of the circumstances of the assessment, mistrust and misunderstandings. And then non-attendance by those who might benefit also happens, which reflects a lack of information about the potential benefit of going to that appointment. So it's not surprising that few people are identified by medical teams and appropriately rooted out of detention at that stage before too much harm has occurred. But the safeguarding obligation on IRC healthcare teams doesn't stop there. People who are identified at any point, we've heard, should be reported by that Rule 35 process, which should report those at risk of harm to their health, at risk of suicide, or who've had a history of torture. I'm just going to say a few words just picking up the risk of suicide there, but other data is included in our audit report, which is actually available here. But just to give an example, in our 66 independent medical reports audited, we found that the risk of suicide had been increased by immigration detention for 43 out of 66 of those people who had significant mental health issues in detention. And yet only 5 of those had had their suicide risk reported to the Home Office by IRC clinicians. 13 of that group had actually attempted suicide in detention, and of those 13, only 3 had been reported as being at risk. As I said, those are quite up-to-date statistics. As Kate Eves has said regarding those catastrophic failures in 2017, it wasn't because the safeguards themselves were poor, but because there was too often a widespread disregard and lack of understanding of how to implement them. And unfortunately, our data shows that this continues today. Failures to identify those at risk of suicide, it wasn't because the IRC staff did not know they were at risk. In fact, 28 of our 66 people were put on suicide risk observations, 15 were on constant watch. It's just the same kind of point that Kate Eves made about 2017, and this did not trigger the safeguarding processes which should have identified those people at risk in detention. Our report, as I mentioned, it describes this and other failures across the safeguarding processes, across all the IRCs in England and ongoing to the present date. It's hard data. I want to just finish by just reminding myself and all of us that the bottom line is not only that health is harmed in this situation or that suicide risk increases, although unfortunately, as we've heard from, of course, that happens. But these are safeguarding processes to prevent mistreatment, to prevent the kinds of abuses that happen when people's health is not managed. Thank you.
Thank Thank you very much indeed. I'd like now to go to my old friend on my right, who I've known for longer than either of us probably wish to admit to, Dr. John Chisholm, who has had a stellar career in medical politics, doing just about every job possible. Fairly recently, he was the chair of the BMA's Medical Ethics Committee, and in that role, he oversaw our report called Locked Up, Locked Out, which was our report on health and human rights in immigration centres. John, welcome.
Thank you very much, Andy. I want to focus my opening remarks on the role and responsibilities of the BMA in this area. And since the early 1980s, the BMA has been involved in defending and speaking out about human rights. We published that report that Andy's mentioned, Locked Up, Locked Out, in 2017, with two main aims: to demand action from the government and policymakers on aspects of detention policy and practice which are detrimental to health and to health-related human rights, and to support doctors and other members of the healthcare team in providing high-quality care to those who are detained. And we quoted Stephen Shaw at the beginning of our report. Stephen Shaw had stated, "It is simply inconceivable that these cases of people in immigration detention would be so little known if they involved children in care, hospital patients, prisoners, or anyone else equally dependent on the state." The UK operates one of the largest systems of immigration detention in Europe. And this policy is part of the government's hostile environment policy, a concept promulgated by Theresa May when Home Secretary, the disastrous consequences of which have been so graphically demonstrated by the Windrush scandal. More and more restrictive legislation is being brought forward, legislation which is incompatible with international humanitarian law and human rights obligations. And more hostile rhetoric is being heard, including the continuing use of the false term illegal migration. The BMA believes that immigration detention should be a measure of last resort and should only ever be contemplated when an individual poses a threat to public order or safety. So we believe that immigration detention should be phased out and abolished. It should be replaced with an alternative, more humane means of monitoring. And there should be, as the Brook House Inquiry has rightly recommended, a clear time limit on immigration detention, without any revolving door policy, as exists in other countries, under which detainees leave and are promptly detained once more. Indefinite detention exacerbates vulnerability and causes deterioration in physical and mental health. And we have policy from our BMA annual policy-making meeting deploring the inhumane conditions which migrants suffer when imprisoned in detention centres, calling for an end to indefinite detention, and calling too for the closure of detention centres. There must be no infringement of detainees' health-related human rights. Detainees should have full access to high-quality healthcare, and we've heard this evening how that very much is not the case currently. That high-quality healthcare must be equivalent to that available to anyone else in our country. Equivalence of care means that care must be timely and appropriate, that care needs must be met in the most appropriate setting, that referrals can take place without let or hindrance, that continuity of care is ensured when people leave the detention setting, and that the principles of entitlement to privacy, confidentiality and consent and to respect and dignity are maintained just as for any other patient. Detainees have complex needs, they're vulnerable, they've often been the victims of torture, yet they're detained in an environment that is detrimental to their health and well-being. Additionally, detainees are often moved between IRCs, usually in the middle of the night, without explanation and without obvious purpose, and are then assessed when they're tired, confused, and when assessment is made more difficult by language and cultural issues. So, to conclude, in my view, the current arrangements, which continue as part of a deliberate policy of hostility to immigrants, refugees, and asylum seekers, are a national disgrace. Our country is demeaned by this affront to justice, fairness, and human rights, and we must continue to lobby, advocate, and campaign for change, and to rid our country of this performative cruelty that is going on.
Now you know why he's had the career that he has had. Thank you so much. On my far left now, I'm delighted to introduce Stephanie Harrison KC, who is a leading public law practitioner who specialises in immigration and asylum rights.
Thank you very much. As I indicated when I asked the question to Dr. Paterson, I was one of the barristers who was instructed both in the judicial review that resulted in the public inquiry being instigated, and then as lead counsel for a number of formerly detained people and medical justice. I'm grateful to be here today to deal with what is really one of the most challenging aspects of what the Brook House Inquiry found, and that is the role of doctors and medical practitioners. There's no shortage of guidance about what the ethical duties of a doctor are, and you can start off by the foundation principle that doctors have to act in the best interest of their patients. That's their priority, that's what dictates everything they should do. But that is not what happened in Brook House, and I can say with absolute certainty that it will not be happening now in Brook House or any other immigration removal centre, because it's quite clear that when you analyse the evidence and you look at the findings that were made, that in every core respect, the guidance that's been given from a number of different sources, and one that I looked at was from the Physicians for Human Rights, which I think Dr. Chisholm and others in the BMA contributed to. Doctors, unfortunately, breach those duties, and I'll list some of the key ones that they did not comply with. They subordinated their independent judgment to support conclusions that favoured the state or a third party, and they did that in the context, as you've heard, for example, of authorising the use of force on a man who had a severe heart condition, and when use of force could have been life-threatening to him. They limited and denied medical treatment and information related to treatment in order to effectuate policy or practice of the state. And they do that in the context of the failed reports that you've heard about evidence of torture and in particular the failure to record ever at Brook House that individuals were exhibiting suicidal ideation, suicide risk, and a very limited number of reports that identified continued harm if the person was detained. The rule refers to injurious to health. Those very few reports in which doctors identified that as a likely consequence of continued detention and had no regard to the fact that the policy, the Home Office Act policy, the adults at risk policy, is about particular risk of harm, probably a lower threshold. But either way, they did not see it as their role to identify the fact that continued detention for this cohort of highly vulnerable people was likely to cause particular harm, resulting in, as Kate said, the failure of the fundamental mechanism for identifying those who are unsuitable for detention so that they are released and will not be subject to further harm. They also performed evaluations for state or private purposes in a manner that facilitated violations of of human rights. And again, that's reflected in the fact that they were complicit in the, central to the failure of all detention safeguards, and did so in circumstances where, if you read the evidence, it's clear that they put the Home Office's priorities of enforcement over the welfare of their patients. And one does also have to raise the question where you do have a situation where the lead medical practitioner in Brook House had a private stake in the fact that he's the person who runs the contracted out service. So he also had private interests as well. And I don't necessarily have to personalise that. It's a fact of it, but it seems to me to be a fundamental problem that the person providing and responsible providing not just medical care, but also the safeguards, detention safeguards for vulnerable people, has a personal interest, a financial interest in the provision of that service. And finally, and perhaps most tellingly, they remain silent in the face of human rights abuses committed against individuals in the care of them as health professionals. And as you've heard from Kate, she recorded 19 incidents of evidence, credible evidence of mistreatment, which would constitute inhuman or degrading treatment. That's 19 incidents in a limited 5-month period. And those are incidents of actual physical abuse. There also include incidents of individuals who, in acute distress, whether a result of mental health or other physical problems, there was a person suffering from a spice attack who was having something that looked like a seizure, not being given assistance, but instead being subject to humiliation, degrading treatment, disregard for the fact that they were suffering a health crisis, and also people who were experiencing significant deterioration in their mental health, requiring intervention. The only intervention that was generally provided being use of force, transfer to segregation as the primary management tool for those who are suffering acute mental distress. And it's important to recognise that that alone is capable of constituting inhuman and degrading treatment. You do not need to have a person's hand on your neck or to be subject to physical harm to experience inhuman or degrading treatment. Exacerbation of an existing, naturally occurring condition, such as a mental health problem, when you're in the control of the state, as you are in a detention facility, is well recognised by the European Court of Human Rights and our own domestic courts that have frequently found breaches of Article 3 in similar contexts for simply exacerbation of existing mental health problems when it reaches a certain level. And in many cases, there was evidence of that. And there was also evidence of racism as a pervasive aspect of the treatment and as an explanation for part of the explanation for the dehumanising desensitisation that also occurred and that Kate identified. Racism in the context of a vulnerable person who's in an imbalance of power situation, as you've heard, is also capable alone of constituting at least degrading treatment, and there is legion evidence of that. So that is the form of mistreatment that was taking place at Brook House, and I will guarantee that it is continuing to take place now. You've heard already the experience of which was in October of last year. And what does that mean, therefore, for the role of doctors currently in IRCs? And it cannot be that they can continue to fail to meet the obligations that are recognised to be placed on doctors. They must end their role in the systemic failure of the safeguards of Rule 34 and 35. They must stop being complicit in this systemic and widespread use of force on those who have vulnerability. You've heard from Dr. Paterson that the methods that are being used, and they're still being used, there has been no change in the methods of use of force that is taking place, are inappropriate for the cohort of people who are held in those facilities, and particularly if they're suffering mental health problems. And doctors must stop being complicit in the systemic and widespread misuse of the power to segregate as the means of managing those who are suffering mental health crises. They must also stop being complicit in these forms of mistreatment by failing to report and to identify and to call it out. It is stark that doctors did not do that, even though that's a central part of their role as medical professionals with independent duties to their patients. And they must stand up and say that the culture that, in which all of this occurred, and which is still entrenched within those institutions, the cultures of dehumanisation and racism, they must be calling it out. They are not, doctors are not doing that still, nor other medical professionals within those facilities. And finally, and critically, they must help to address one of the key aspects of the cultural, institutional culture that led to this abuse and continues to allow it to happen, and that is of impunity. And they must use their role as independent practitioners with duties to the individual patient that outweigh any other priority to be a force for challenging impunity. And they have to, it seems to me, have a fundamental re-evaluation of what their function is in that facility in circumstances where none of the recommendations that were made have yet been implemented, and there is no indication yet that they will be. And they have to consider that their primary function is the identification and the reporting of ill treatment of the kind that was identified in the report. It may not be, and I don't say that the strangulation, the extreme form of abuse that was identified by Panorama, that will be taking place, although you can't exclude it. But other forms of systemic misuse of force, of the failure to identify people who should not be in detention, all of those factors, they need to be there to be identifying and documenting what is mistreatment within the terms of Article 3. They must look at their work through the prism of the Istanbul Protocol and the documentation of torture and ill treatment and degrading treatment. That has to be the foundation for their role within that facility. Of course, there are other functions. You have to deal with the person who's got a headache or is sick. There's a practical role for what doctors have to do in a detention facility. But given what we now know and have well documented, we've known it for a long time, but now we have it properly documented, authoritatively so, as a result of the extensive inquiry that was done. Doctors have to begin to operate in a very different way. And insofar as the BMA has a role in education and in issuing guidance, I know that guidance has been issued on a number of occasions, but I think it does now have to take account of the fact that we have had exposed the systemic risk that there is operating right now, that other people will be subject to the same forms of mistreatment that occurred and are occurring. And so I would ask that the BMA does think about what guidance it might give to those who take on that role in this particular context, and that they do so by emphasising that their function is one that is directly governed by the Istanbul Protocol on the recording of mistreatment, and that their central role must be to identify and call out mistreatment where it's occurring, and to do so as loud as they possibly can, to be the voice that was not there, because we cannot assume, again, that an undercover reporter will expose this. It has to be from within the detention facilities themselves, and doctors and medical practitioners must be best placed to have that role.
Thank you. That was immensely sobering. Thank you very much indeed for that. And in fact, one of the things the BMA mentioned in our response to the Brook House Inquiry was that we did not feel that Brook House was going to be exceptional. We felt that probably this was an illustration of what was going on all over the country. We're now going to move. We have about 10 minutes available for Q&As. We have some submitted already. Please put your hands up from the floor as well. We can take questions from the floor. I'd like to ask, I was a GP trained. I did safeguarding. I did a psychiatric post in my training. By the end, I was pretty experienced, but I know full well that there is no way that I could work effectively in the environment that I saw in that Panorama documentary. So can I ask, perhaps starting with Rachel, what training do GPs get who go into these very difficult situations, and is it effective?
Well, I mean, unfortunately, I think that our evidence, the evidence before the Brook House Inquiry and the evidence to date shows that it's manifestly not effective because these safeguarding processes are not being followed. I think there's a number of reasons for that related to issues we've heard about to do with cultural factors and other pressures, a lack of a failure to take seriously just how important and vital these issues are, which I'm glad we're discussing today.
Thank you. From the psychiatry point of view?
I mean, there are relatively few psychiatrists that go in regularly to IRCs. I don't know of any specific training they have. Anecdotally, I know that the psychiatrists who work there very often don't work there for very long for reasons that I don't think I need to spell out. If I could make one related point, I mean, I absolutely agree with what Stephanie Harrison said about the need for doctors to be the sort of the final safety net. But there shouldn't need to be that final safety net because the culture should change, and there should be a culture in IRCs, and largely I would like to think there is more of that culture in prisons, although it's not a good analogy as others have said and I have said. But I think there is this fundamental problem with the culture, and having the doctors as the long stop is not a good solution.
I think that doctors and all healthcare professionals, but also support staff in IRCs, do need support and education and training, and they need training in ethics and in human rights and in the obligation to raise concerns rather than suppress those concerns. I think one of the issues is that in some IRCs, doctors and other healthcare professionals get very professionally isolated and also are insufficiently aware of the tensions that are created by their dual loyalties. We've heard from Stephanie about how loyalty to the state and to the Home Office often dominates their obligation to the patient, whereas it should be the other way around. And so I think that we need more training and support and education, some of which is starting to happen, including training in producing Rule 35 reports. But we need to do something about trying, if possible, to break down that professional isolation.
Thank you. Stephanie, do you wish to add?
I think that it does require the fundamental changes that have been identified in order for doctors to carry out their role properly. So whilst I've focused on what doctors should be doing, that's in the interim. That's in a context where all of those same patterns of behaviour and institutional culture exists. That's why I've focused on doctors. The only solution has to be the radical changes that were part of the recommendations, and in particular there has to be a time limit on the use of this power, because if it's not restricted, the evidence is extensive and widespread that it will be abused, and inevitably people who are held in detention for longer than 28 days are at the risk of very serious harm. So for me, the solution is the recommendations being implemented, but in the interim, I have to say, I can't see any other professional within that institution acting who has the same duties as a doctor and a medical practitioner to take on that role.
Thank you. We have a question from the floor.
We're asking for change in culture structure of the way that doctors who are working in IRCs look after the people who are there. There's in order to do that, there will inevitably be a certain amount of whistleblowing. And unfortunately, we know how people who act as whistleblowers tend to get treated. How are we going to support these doctors, both by educating them and by looking after them so that they know that if they do blow the whistle, they'll be supported by somebody who can really, really support them?
Thank you. That links in with another question that we had actually, which is if a healthcare professional working in one of these centres finds themselves in difficulties either clinically or administratively, where is the source of support for them? So could we start with Cornelius at the end?
I mean, it's a very important and very difficult question. I mean, I think that part of it needs to be by example. There need to be visible examples of people whistleblowing and being praised for their whistleblowing and change flowing from that whistleblowing exercise. And so that is one element of the change in culture would be to make whistleblowers feel more safe. But that isn't by a change in paper policies. And I was very struck by what Kate Eve said about the safeguarding policies in IRCs being pretty much fine. It's just they weren't implemented. That sort of huge difference between the bit of paper and the implementation. And bits of paper, as I've said ever since I was a trainee, are not things for people to cover themselves with. You know, the bits of paper should serve a purpose. They should be honoured in the action, not used defensively. But I think that is something that, as I say, has to be seen to be done, not just argued for.
Rachel, this sounds right up your street.
Thank you so much. Yeah, I mean, great question. Thank you. Essentially, it does require a huge transformation in viewing of the role, which would need to be very well supported, as the questioner points out. Doctors in this situation have to be completely independent, and they would need to think about that in all of their practice, in all of their supervision, in all of their interactions. And I think that that is a very different situation to the one that we're looking at today. Even from our clients' perspectives, they don't view IRC doctors as completely independent. That affects the interaction from the start, the way that reports are written, the failures of follow-up, the failures to follow through and reassess safeguards. I think at every level, these things would need to change for doctors to be able to exercise that independence. And, you know, I like being an independent doctor, seeing people and being able to write something objective and do an assessment. It is the proper use of medicine. It's very rewarding and fortunate to do. So I think doctors that are able to work independently as their patients' representatives and advocates in the interests of healthcare will probably have a better time, I can say. But I think we're very far from that situation at the moment.
Thank you very much. Time is very much against us. I'm just going to squeeze one more, if we can be as quick as we can, and we'll have quick responses too, please.
Essentially, it's a question about accountability. I think there are two levels of accountability. One is doctors' accountability. The other is accountability of the Home Office. And the Home Office suffers the barrier of outsourcing, which you raised. So that's an issue, what the English legally otherwise is. We want the judiciary to be able to actually make the ones responsible for what's happening. What legal mechanisms there may be to ensure that happens. But with doctors, I know from my experience, a number of years of working with the ethical department here, we have to accept that many doctors actually believe in hostile environment. They have the same attitude towards immigration that perpetuates hostile environment. And those are some of those who end up in the system administering hostile environment. So I think the accountability actually is more role put to the GMC, to work with the DMA, to work with the GMCs, and they can be actually registered to work in this environment. And our registration can be taken away from them. So individuals are accountable not by their good behaviour and their detention, but by their actual through processes and mechanisms which are dependent. I think those
Thank you for anybody who had...
those levels are the only way to make real progress.
Yeah, and then very quickly behind.
Yeah, I'll try to be quick. First of all, thank you to all the speakers. Just to say, it was really interesting to hear the discussions, because at the moment in Italy, doctors are discussing kind of similar issues, and what they're doing, like, I think which is extremely, like, important, and maybe also the inspiration of the setup of a campaign of civil disobedience, because in Italy doctors are required to certify that the person is fit to be detained, and so doctors who have a social justice orientation have started to set up tools and set up a campaign for other doctors in the public sector to be able and have the strength to say, no, I won't certify that someone is fit to be detained, because no one is fit to be detained, because this is harmful to everyone. And so I was just wondering, first of all, sharing this, which is just very at the beginning, so we are trying to build this and enlarge this, but also to ask, would this be possible in the UK context, and what are the possibilities? Thank you.
Two very interesting points, thank you. I think I'm going to exert chairman's privilege and take those as points made from the floor rather than specific questions in the interest of time. Thank you all very much. I would like you please to thank the panel of Rachel, John, Stephanie and Cornelius, who I think have definitely proven their worth. Thank you very much. And now I'll hand over, please, for conclusion.
Right, well, as Andy said, thank you to our panel members, thank you for all the other speakers as well, and to all of you for participating in this event, and what has been, I'm sure we can agree, a very informative evening. As we're coming to the end of the event, me and Adele thought it would be a good idea for both us, as in the BMA, and the medical justice, to discuss some of the actions we've been taking and what we will be doing going forward in this extremely important area. So, as John discussed, the BMA has continued to highlight its concerns regarding healthcare and IRCs, both with the government, including the Home Office, and various other stakeholders. We responded robustly to the findings of the Brook House Inquiry, underlining the systematic failures in Brook House and how this echoed the issues raised in our report, Locked Up, Locked Out. As John also discussed, we at the BMA do not think that the issue around healthcare in IRCs can be separated from the general hostile environment policy of this government. So therefore, more generally, with respect to migrant healthcare, during the passage of the Illegal Migration Bill, the BMA briefed MPs and peers on the BMA position throughout the passage of the bill even, setting out the medical and human rights consequences of the bill and firmly opposing it on these grounds. We also explicitly advocated for the development of a single, fair, humane and effective refugee system in keeping with our obligations under international humanitarian and human rights law, including rights to necessary and appropriate healthcare irrespective of an individual's route into the UK. The BMA opposed the Nationality and Borders Act, and we have consistently cautioned against attempts to expel asylum seekers from the UK to Rwanda, emphasising significant ethical and medical concerns. The World Medical Association Council supported an emergency motion from the BMA on the issue, and we have hosted a webinar with Medical Justice and MSF on our concerns. We issued a statement welcoming the Supreme Court ruling that the government's Rwanda policy was unlawful, and have since briefed parliamentarians on our opposition to the safety of the Rwanda bill. The BMA will continue to defend the health rights of migrants, including those held in IRCs, and we will continue to lobby for them to receive high-quality, suitable healthcare and call out shortcomings in this area. As John mentioned, this is vital not just for migrants, but also for the healthcare staff who work with them. Finally, I'd like to thank you all once again for attending this event, and thank you also to Medical Justice for co-hosting it with us. And with that, I'll hand over to Adele to give the final remarks on behalf of Medical Justice. Thank you.
Thanks again from Medical Justice and the BMA. So a few comments from Medical Justice. Having been a core participant of the Brook House Inquiry, we're working closely to follow up on Case 33 recommendations, including briefing parliamentarians, advocating directly with the Home Office, and working in coalition with many other organisations, including medical bodies and NGOs. We also continue our research, the latest of which documents a recent audit that that Rachel mentioned, and it's available at the front. We of course continue to support individuals in IRCs, as has been mentioned today. We continue to see the same conditions as exposed by the inquiry. Immigration detention is administrative. It's not part of a custodial sentence. So that's why we and the BMA say that it can be phased out. The Brook House Inquiry unequivocally places responsibility on the Home Office, urging action at the highest levels of government. Kate Eves has asked for the Home Office to respond to the inquiry's recommendations by March 2024, 6 months after her report was published. So far, the Home Office has not acknowledged the severity of harm ongoing in detention and continues to turn a blind eye to the failures over which it presides. They continue to suggest that these are the issues of the past and that we are in a different place now to where we were in 2017. Our speakers have shown that the very conditions that led to the abuse and mistreatment exposed by Callum Tully and by the Brook House Inquiry continue to put vulnerable people at risk of such harm. And given the current political climate, with increasing detention capacity, the Illegal Migration Act and the safety of the Rwanda Bill, these messages are ever more important. Medical evidence and the voice of healthcare professionals are going to be increasingly important, both at the individual level, to make a real difference in people's individual cases, and also at the structural level to hold the government to account and provide expert input. Medical Justice are actively recruiting volunteer clinicians, and we have our basic training day coming up on Saturday the 16th of March, and you can apply to come along to that on our website, or there are a few posters around with a QR code that you can sign up with. We will continue our advocacy work as well, and we hope to work in coalition with many of you here today to continue to do that, and we'll be in touch about joint actions in the future. So we hope that this event has been insightful and that you continue to follow the situation in immigration detention and advocate where you can. Thanks very much to the BMA for facilitating the event space and for co-hosting. Thanks for everyone for attending. Thanks to our speakers, and thanks very much again for taking the time to speak.